Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning, everyone. Please be seated. We are here today for the submission of 4 cases. The case of State of Iowa versus Mumford is hereby submitted without oral argument. The case of Iowa Supreme Court Attorney Disciplinary Board versus Patricia Lipsky is also submitted without oral argument. Our first oral argument today is 1,000 Friends of Iowa and others versus Polk County Board of Supervisors. Ms. Ibson, you may begin.
Thank you, Your Honor. Good morning. May it please the court and counsel. Last term, this court issued several opinions regarding statutory interpretation and construction that I think frame our discussion this morning. In Randolph versus Sioux City, this court correctly noted that courts do not write statutes. Rather, the legislature writes the statutes, and the court's role is to apply the words chosen by the legislature. On this point, the court cited Vout versus Wells Fargo Bank, in which our trial judge in this case and her husband were the plaintiffs. In Rivera versus Clear Channel Outdoor, a landowner argued that Iowa Code section 614.17a cannot apply to an action to clear an easement. And Justice May, writing for the court, you agreed, because by its terms, that statute can only apply to claims against a holder of record title to the real estate in possession, and easements are not possessory interests. In Randolph versus Sioux City, this court was asked to decide what the words based upon meant in the context of section 670.4J of the IMTCA. If words aren't defined in a statute, we give them their ordinary meaning. And there are 3 words that matter most today: tort and monetary damages. This court has defined tort over the years, most recently in Victoriano versus Waterloo. And I think we can all agree on an ordinary meaning for the phrase monetary damages. And Votz versus Northern National Gas, a gas utility, argued that the legislature's amendment of section 657.1 to provide a comparative fault defense in actions to abate a nuisance against an electric utility evidenced the legislature's displeasure with allowing nuisance claims across the board. And just, let's
talk about language. Section 670.1 sub 4 defines tort, and it says it includes but is not restricted to actions based upon negligence, which is not your claim, but then it says error or omission, which I think your claim could fall into, and then it goes on to say, or denial or impairment of any right under any constitutional provision, statute, or rule of law. And as I read your petition, impairment of any right under a statute, I think is that claim. What am I missing?
Part it is, and I'm going to get to that because I'm going to talk about in just a moment whether plaintiffs like my clients could ever comply with the heightened pleading requirements in these new amendments. Error is not the word that our statute uses. We're challenging the legality of the board's action in approving this amendment. And so I don't think it falls under that one. If it falls under any of them, I suppose it could. But again, we can define tort, but this amendment has 2 parts. It's not just tort, it talks about monetary damages, which are not at issue in our case. So if I could get to, maybe in just a moment, try to clarify that for the court. I'll focus on one other opinion that came out recently, and that was just last Friday in State versus Harris. Again, Justice May, you wrote, this court reiterates that its charge is to give statutes reasonable interpretations, okay? The trial court adopted the board's argument that section 670.4a is, quote, intended to provide a procedural framework for all actions against municipalities. Of course, absent from the record is any evidence of any such intent. The amendment at hand is a declaration of public policy by the legislature. It was commonly referred to by our elected officials as a back the blue law. It is a declaration of this policy. We support law enforcement, and the declaration was made in the context of a broader national discussion following the death of George Floyd and the civil unrest that followed. To discern the intent of our legislature, we have the benefits of their words from the transcripts of the debates on the amendment.
Legislature doesn't like us when we do that. I mean, for some reason, it's okay for them to rely on the words, but not for us. One thing that occurs to me is, can we just rely on the common meaning of the word tort? Because, Scalia and Garner, for example, say in defining a term, even when it's a defined term that's defined by the legislature, one of the most important elements of the context of the term, and I think I'm paraphrasing our decision in State versus Ross, one of the most important elements is the common meaning of that term. And are these torts within the common meaning of that term?
Well, I think they are not, because tort encompasses personal injury or property damage, neither of which are at issue here. This court certainly has defined tort. I think in the last time Justice Waterman, you looked at it, was in Myers, that Justice Waterman wrote the opinion in Myers versus Cedar Falls, was tort claims and immunity for aquatic recreation facilities and criminal offenses. And they're talked about legislative intent. And then, of course, in Victoriano, I don't want to say expanded the definition of tort, but said, well, sure, strict liability claims are encompassed by tort. So I think this court has the absolute authority to give a definition to the word tort. I don't think that what we're talking about in this case falls within that definition. It simply doesn't.
I think the legislature gets to be its own lexicographer, right? It gets to define terms the way that it sees fit. And if it defines tort in an overly, what might be an overly broad sense, don't we have to apply that definition?
But they haven't. And I get back again to, I want to talk about that Myers case, because here, one of the issues in that case, or one of the comments by this court, was when the legislature selectively places language in one section and avoids it in another. We presume it did so intentionally. I mean, here the legislature placed this new language in just one section, I mean two, if we count the State Tort Claims Act, but avoided it in many other statutes that govern proceedings against state and municipal actors. The code is simply silent in all these other places. So I want to answer your question now that you posed a moment ago, because one question I wrestled with as I prepared for this argument was, could any plaintiff who files a petition in equity pursuant to Code Section 335.18 and Rule 1.1401 ever satisfy the heightened pleading requirements of this amendment? And I think maybe the answer.
Point, but I want to interrupt you 1 second and talk about the 674A issue generally, which is, if I understand it right, the law applies to claims against employees or officers under 674A sub 1. Is that right? Is it even applicable here? Because if I read the pleadings right, your claim is against the Polk County Board of Supervisors as an entity.
Correct.
670.1 defines that differently as a, quote, governing body and not an officer or an employee. So is this even relevant to this case?
I mean, we obviously argued that the Tort Claims Act has no bearing on this case at all. I mean, that's our argument from the beginning. It simply has nothing, we're talking apples and oranges. This is zoning, that's tort claims.
At it is, are you bringing a claim under this chapter, meaning under 670? I mean, you don't need 670 to bring this claim.
Claims under 335.18. So, getting back to why I answered my question, could we comply with? Probably not. Iowans have a clearly established, and those words matter, right? A clearly established right to, for example, practice our religion free from government interference. We have a clearly established statutory right to a workplace that's free from discrimination. A trial court doesn't get to decide if we have those rights. They are clearly established. The trial court can only decide, one, whether our rights are violated, and two, what amount of monetary damages is fair compensation.
Standing, right?
Two, Chief Justice. While my clients have a clearly established right to file a petition for a writ, they don't have a clearly established right to the writ itself. I mean, the trial court gets to decide whether the writ issues. In other words, whether my clients have the right we claim. If denied, if our writ application for writ is denied, the only recourse is an appeal. And of course, this court has entertained any number of such cases over the years, although more often in the context of judicial acts, I think, including the case you're going to hear next, the DePaco versus Lynn County District Court case. I'm going to skip more on legislative intent because I think we've addressed that fairly well in the brief, and I'll stand on that. But I do want to talk about two things. The Chief Justice just brought up the subject of standing, and that, of course, was an issue before the district court. And it seems to me that if this court wants to avoid ruling on the 670.4A issue, one way to do that is to reverse the district court on standing, okay? Iowa is and has always been a notice pleading state, with one notable and recent exception, and that is Section 670.4A and its state counterpart. The board concluded its brief to this court. The individual plaintiffs may, in fact, have standing to bring this challenge, but we didn't plead sufficient facts and interest to confer standing. At the May 5, 2023 hearing before the district court, the board conceded that, well, any deficiencies in our petition could be cured by amendment. But of course, that process was lost to us when the trial court invoked Section 670.4A.
Right? Under the Victoriano case, didn't we say that a party still has a right to amend, even in light of 670.4A?
Say that if the motion to amend is prior to dismissal with prejudice. Once the court, and again, this issue came up, to put it in context, we have this hearing.
Mike, that's okay, thank you.
Hearing before the district court, and we're arguing just standing. I mean, you can see that by the pleadings. And then at the very end of it, counsel for the board says, well, these plaintiffs, might have standing if they pled some additional facts, but by the way, 670.4A requires this court to dismiss with prejudice. I requested leave to brief that issue because, frankly, I was kind of shocked by it. And so I did, and that was the issue that the court addresses in its order. Now, she does talk about standing, certainly. Yeah.
To amend your petition?
We did not. And again, had this code section not been invoked, any dismissal would have been without prejudice, which at that point, of course, I'm going to file a motion for leave to amend with relation back as part of that, because, of course, we only had a 30-day window to file this, which is, effectively an appeal, right? So we would have had to have argued relation back, and I'm not going to, argue the law on motions to amend. The court obviously knows that. But that's what we would have done. But again, that's denied to us by the fact that the trial court says, well, you're just done because, this amendment to the State Tort Claims Act applies and your claim is dismissed with prejudice.
Your individual clients received notice of the zoning change? Now, is there anything in the record about who did and who didn't? I mean, what were the criteria that the county used for notifying people?
I mean to interrupt. If you look at our brief, you're going to...
Question, go ahead.
Language on that. So this is a somewhat unique situation, and then we have this subject parcel, and every parcel around it is owned by members of the parcel seller's family, right, the Geisler family. And so, and particularly because these are larger parcels in an unincorporated rural part of the county, the board, and the commission were very purposeful in sending notices out to folks so that they knew about this. So they didn't follow this. I can't remember what it is in the city of Des Moines, but if you're within X number of feet or miles of something, you get a notice. They did send them out.
But I mean, they didn't notify everyone in Polk County. I didn't get a notice.
But I live in Beaverdale, so I mean, I don't really have any vested interest in.
I understand. Is there anything in the record about who did get notice? I mean, how far did they go out in terms of noticing?
Precise, we sent notices to everybody within, 5 miles. I'm not sure that that's in there, but there certainly is information regarding that. So going back, I'm sorry.
Is in that petition that would tell us the proximity that your clients live from this subject property?
So that's one challenge that the board brought up in their motion to dismiss. In the motion to dismiss, I establish where the subject parcel is. I establish the ownership of all the parcels that surround it. They're all members of the Geisler family. And I give the addresses of the parcels owned by the individual plaintiffs in this case. And I got all that information from the county plat map, which I assume would be as available to the board as it is to me. So going back,
Is that county plat map something that we can look at in this record?
it was never an exhibit, so it wouldn't be part of the record in this case.
How would we know how far your client's properties are from the subject property?
Well, that's a good question. I guess I would frame the question as what matters is that the defendants knew, or that the defendant in our case knew, because again, if we go back to the standards for a motion to dismiss, you're challenging the legal sufficiency of the petition. Does it fairly inform the defendants of what the claims are? I mean, this was a 20-page petition, 18 of which was wholly or partially comprised of facts pled in support of our claim of standing as persons aggrieved under 335.18. And I guess I find it difficult to imagine that the board received that petition and said, gee, I wonder what this case is about. I don't know if that fully answers the question. The addresses are in there. And again, we can go to the four-part test from the Florida case about proximity. I mean, we do plead, these folks are all people who own land in the proximity of the subject parcel, and who have, they live in that part of the county for their reasons. I mean, the same reason I live in Beaverdale, you choose where you want to live. Yes.
Up for the first round, and then I will, okay, thank you.
May it please the court, counsel. Justice Mansfield answered the question that you asked to opposing counsel. I believe the only information in the record, given that we were just at the pleading stage on who received notice, is the allegation contained in the petition in paragraph 24. And that paragraph states that Polk County, recognizing that adjustments to rural zoning necessarily have different interests than in urban areas, expanded who received notice. It does not give the parameters of that expansion on notice, and it does not state that the plaintiffs themselves received notice of the zoning reapplication, which I think is a very significant omission here. I understand that counsel has stated that to the court. I'm not sure the record supports that factual assumption here. I also believe that the
Point. Can we take judicial notice of how far it is from their address to the subject property?
I think that you can potentially. I think it's difficult. I spent a lot of time preparing for this argument, and I was looking at the addresses. And perhaps there is certainly some common sense that the court can apply when reading a petition about how many blocks you can confer away. Again, this is in a rural setting. I'm not sure that common sense applies as well.
You take judicial notice.
And I do think there is a difference between, we're kind of convoluting the arguments, and perhaps in part because of how I framed them, between pleading and standing. These are two different things, even under a notice pleading. Whether defendants obviously had knowledge of what the complaint was, never denied that fact. Whether the plaintiffs have standing is a fundamentally different question than their pleading requirements.
On that question, 670.4a, we have said, addresses three things, two of them particularity and plausibility. Do standing allegations have to be pled with particularity? And does the plausibility prong apply to standing or just facts?
I think it does. It is not a perfect fit, but I do think when you are alleging particularity, that does go to standing, is it goes to what your interest is in the outcome. I know the wrong was pled with particularity. The board will admit that, but I don't understand the plaintiff's injury vis-a-vis that wrong. So I think that does, in fact, go to the particularity requirement. And then their ability for success goes to the plausibility requirement. Now, while I have a personal interest in 670 matters and how it applies to claims against my clients generally, I don't think this court has to weigh in to that to resolve the matter here. Both before the district court and again on appeal, the board alleged that the complaint fails under both the heightened pleading requirements of 670 and this court's general notice pleading because of the lack of pleading outstanding.
We get into the issue of whether they can replead, right? Isn't the question whether it's with prejudice or without?
Would agree, Your Honor. I would say, though, at that point in time, I believe that question is moot. I don't know if the plaintiffs requested a motion to recast as an alternative before the district court. And at this point in time, if you dismiss with prejudice, a refiling would be beyond the statute of limitations. I would also point out that whether it's under 670 or the General Rules of Civil Procedure, nothing prohibited the plaintiffs from filing an amended petition following the defendant's motion to dismiss. Filing a motion to dismiss in and of itself is a little bit of a Hobbesian choice, where you have to lay out the deficiencies as you allege them. Nothing prohibited the plaintiffs from fixing those deficiencies, adding the particular distances from their properties to the subject property, adding the requirement that they were personally served with the notice for the zoning amendment change. Those deficiencies were pointed out, and there were months in time that amendment could have been made. It's also a question of whether they could have made that amendment following the district court's hearing. That is an open question that this court didn't address, I don't believe, in the combined Nahas and Victoriano cases.
Status as taxpayers alone sufficient to confer standing under the language of the statute?
Two reasons, Your Honor. The first is that the zoning application itself has no effect on their paying of taxes. It is not the zoning or the rezoning application which affects whether or not that parcel in question is taxable. It is the identity of the potential buyer at the time, the family leader, that potentially affected its taxability. I would also
I guess the statute doesn't put in any qualifications about the taxpayers being harmed. It just says any taxpayer can file this petition. If we were just to follow the terms of the statute, why isn't that enough?
You're looking at 335.7, Your Honor. 18, I do think it was an error that was cited in the brief. This is not an appeal from a Board of Adjustment decision. This was an appeal from a Board of Supervisors decision, and it is very confusing zoning law, and I am far and away not an expert on it, but 335.7, yes, Your Honor. I believe that covers when zoning applications go to the Zoning Commission and then are reviewed by the Board of Supervisors. I think it's immaterial in the sense that under the court rules, a writ of certiorari was still available to the plaintiffs, just not under 3518. And in addition to that, Your Honor.
Go ahead, finish your answer.
I would say if this court also wants to take particular notice, you could take judicial notice of the fact that the family leader has sued Polk County for removing its tax-exempt status, so though there is no damage to the plaintiffs or any taxpayers in Polk County.
Counsel, why isn't there organizational standing here for 1,000 Friends?
Again, Your Honor, I would say, one, I don't believe the petition sets forth a factual allegation that any of the organization's members would have standing. An organization certainly has a right to stand in the place of one of its members. That was not a fact alleged in the petition. I would also say that unlike some of the environmental agencies cited in the case law, in the briefing, there isn't a need for the organization to assume an interest beyond that of its members, as there are people who would have standing, neighboring parcel owners, potentially even these plaintiffs, if pled with sufficiency. So I don't think that we need to expand the definition of organizational standing here when there's not an allegation that any member of 1,000 Friends had standing to bring this claim.
We concluded that you overachieved in convincing the trial court that there was this immunity under 674A was applicable. We could still affirm on the basis of lack of standing. Is that your position?
Position, Justice Mansfield. One, we preserved error, and we have raised that argument throughout the litigation. It was an argument presented to the district court, and it would be an alternative available to this court to avoid the larger implication of examining 670 in the context of what constitutes a tort.
Get the standing question from kind of how close they have to be to the property. What is the dividing line that you're proposing?
I would urge this court, I believe the four-part test in the Dittmer case, the Reynolds versus Dittmer case of the Court of Appeals has adopted and used consistently for the past few decades is a good test. I would not advocate for an explicit dividing line. I don't think there's one set by the legislature. In absence of that, I think that standing should be a multi-pronged concern, and it would be different in a rural setting versus an urban setting. So if you did a pure yards or feet analysis, I think people in urban areas would have different concerns than people in rural settings.
The petition is kind of thin on standing allegations, but if they had pled how far they actually were, and if they had pled that this facility will aesthetically harm them, that they'll have to go by it, they live around it, and if they had pled that they were given notice, presumably because the county thought they were going to be affected by it, if they had said all those things, would that be enough to confer standing?
Your Honor, certainly in the general position, I would agree. I think this case is slightly different in that they would have to be more nuanced in the fact that we are not going from a traditional farm field to like perhaps a residential development. I mean, this is more attenuated given the special use of this property as a commercial facility before this. But yes, Your Honor, those were some of the deficiencies that the board pointed out in its original.
The merits, though, as opposed to standing of who's aggrieved versus whether or not they actually were aggrieved?
Yes, but I think it's also relevant to the second and third prongs of the Reynolds versus Dittmer tests, which this court has not had a chance to adopt officially or consider that I have found. It does go to the significance of the proposed change in determining who would be affected, to determine whether or not the individual plaintiffs would have a legal or personal interest in the change. So I do think there is some relevancy to that when it comes to prongs 2 and 3.
The statute of limitations has run. Could the plaintiffs refile and get the benefit of the 6 months savings provision in Iowa Code 614.10 when an action fails for some reason other than negligence? You can refile within 6 months?
That argument, Your Honor, so I don't honestly know the answer to that question. I would tell you on refiling, I think that we would have a number of issues, not the least of which the zoning decision was made in February of 2023, and the record does not reflect that a stay was ever requested or granted. So I think should this case be refiled or resent down to the district court, there are many additional issues that would have to be raised given the 18 months that have elapsed since then.
Counsel, even under a notice pleading standard, as I look at paragraph 36 of their petition, which I think is maybe repeated a time or two, I think that's maybe their best allegation. And that says, indeed, the individual plaintiffs chose to locate to and remain in this part of the county because it is agricultural in nature. So there is, if we're looking at this with in the light that best puts this this allegation in favor of plaintiff standing, there is at least an allegation that they live in this part of the county. Under notice pleading?
I would say, Your Honor, I would agree that that is sufficient. I mean, I'm sorry, I would agree that that is the closest they get to making the argument. The first half of that paragraph is, of course, the legal conclusion that they have an interest in the property. I would disagree that it's sufficient in the sense that I don't know where they live in the county. There are unincorporated areas of Polk County throughout the area.
Petition, so you do know where they live.
Approximately too.
How,
The distance to the affected property is unclear, and how they would be affected, what roads they would use to utilize to their homes.
Court can take judicial notice of adjudicated facts where they reasonably can't be questioned. If I can put the address in a GPS or a Google and find out that one of these people lives 0.7 miles down the road from this property, is that sufficiently close to give them standing to object to this? How close enough?
I think that's a matter of degree, Your Honor. I don't think the court needs to do that. I don't think it's the onus is on the court to prove that for the plaintiffs. I don't think there is a precise amount of distance that would give them standing.
You should have been specific with distance.
One object to give them, to explain their interests. I also think it's relevant, are they going to pass this property every day? Is it?
Ways. You say they don't allege the distance. Our rules of evidence, 5201, says we can take judicial notice of things that can't reasonably be questioned. I don't think determining the distance is really subject to dispute. So if we can do that, and it turns out that this one of these challengers lives literally around the corner, tell me why that's not close enough under the test that you've proposed.
Multi-pronged. I don't think the distance in and of itself is indicative of whether or not they have an interest in the zoning reapplication. I think that is certainly a factor.
That our court can take judicial notice on its own, sua sponte,
Your Honor.
on appeal.
If the judicial notice rule of evidence applies equally to this court as it did to the trial court.
Ms. Gavin? Thank you. You may be seated.
Thank you, Your Honor. May it please the court. On the subject of standing, and there's been a lot of conversation about distance, I think there's something else that's unique to the plaintiffs in this case, and that is the Polk County zoning ordinance, right? The Polk County zoning ordinance has nothing to do with me in Beaverdale or any of you who live in West Des Moines. It is a particularized statute that governs zoning of parcels of real estate located in unincorporated Polk County. So that makes these folks unique as well. Ms. Gavin brought up taxpayer standing, I think, in response to a question and talked about the family leader case. If the court is interested, that case was filed back in May, and it's Polk County, I had the Polk County case number, EQCE 090220. The family leader did ask the Polk County assessor for tax-exempt status as a religious organization. That was denied. It was denied by the Board of Review, and now they've sued the Board of Review or filed a petition against the Board of Review. And the district court could do anything, and whatever, yes.
335.18 or 335.7?
It is not. It's a tax issue, property tax issue, yeah.
Here that is the appeal that we're talking about today that you're here for, is this a 335.18 or, as your opposing counsel said, it's actually 335.7?
Petition is 335.18, and this issue never came up below. I do agree with her, though, that 335.19 only talks about proceedings involving a board of adjustment, and there's nothing in the statute that specifically says proceedings against a board of supervisors. We just kind of have to go by analogy, because it's the closest we have to try to get the remedy we're seeking. Another argument that was made by the board that wasn't addressed here today is this harmonizing argument. Look, you can...
One second on that. It seems like it's relevant to the standing question what the controlling statute is. So I guess give me a little bit more guidance or a definitive answer. You know, if the statute, for example, said any party within half a mile of the property at issue has standing, that might be dispositive of the case. So where are we supposed to look in terms of statutes that would be relevant to this standing issue?
I'm looking right now at 335.7, and that talks about the process of amending zoning maps. The reason we invoked Section 335.18 is that talks about the procedure for challenging the process in which the zoning commission and then later the board of supervisors engaged. In terms of where do we set this geographical boundary, I would submit to the court, and this is the best I can come up with. I agree with her. I think the minute we start saying, well, it's 1 mile or 3 miles, 1 mile, again, going back, 1 mile in Beaverdale is different than 1 mile in unincorporated Polk County. So I don't think we can do that. I think, again, we need to look, as we do with any statute, what is reasonable. And if this zoning ordinance applies to everybody who lives in unincorporated Polk County, and if these folks have pled that this is why we live here and why we're concerned about this, I think that's reasonable. I've talked a lot about legislative intent. I was going to bring up one other point, but I don't think I have time to do that. So I want to leave you with this, and that is kind of a what's next argument. So let's assume this court adopts the rationale of the trial court and says, yeah, you know, despite that it says tort claims and for monetary damages, these amendments really just create a procedural framework for all actions against state actors. I have a client who applied for an insurance producer license, and that was denied. Okay, so we're going to appeal on that next week before the general counsel for the insurance commissioner, who will act as the hearing officer. And let's assume that that denial stands. Let's assume my client tells me to petition for judicial review of that decision. Did the legislature intend by these amendments that the insurance commissioner of the state of Iowa be protected by qualified immunity in licensing decisions? And if the answer to that is yes, I struggle with how do I draft a petition for judicial review that comports with these heightened pleading requirements? I don't think I can. My client has the right to file the petition, but he doesn't have a right to that producer license. Whether to issue that license falls within the discretionary purview of the insurance commissioner. And so I think, I keep coming back to this point, but I think it's a pretty compelling one that communicates to us that that's why these amendments simply don't apply in cases like this. This is just a little challenge to a zoning map amendment. That's all it is. And to say that it is subject to these amendments, to qualified immunity, to heightened pleading requirements, I just think I have trouble understanding the logic of that. But any other questions? Okay. I appreciate your time. Thank you so much.
Versus Polk County Board of Supervisors is hereby submitted. We'll take a brief pause here for the case of Dupaco Community Credit Union versus Iowa District Court for Lynn County.